I'm Hillary Hayden. I'm the organizing director for the Trade Justice Education Fund. We are a national organization working to stop the damage of corporate-centered trade deals and to promote a positive vision for international trade. These Trade Justice Power Hour calls happen every third Thursday at 3 p.m. Eastern. They cover a wide range of educational topics about trade policy that should be relevant, interesting to activists across the country. I want to flag quickly that they're not intended as press briefings. So if you are a member of the press and you have questions, I'm more than happy to talk to you outside of these calls, but this is not the place for that. So this month, we're going to be focusing on a topic that a lot of you have been asking us about, investor-state dispute settlement and its threat to climate action. As our excellent panelists are going to detail for us in the next little bit, investor-state dispute settlement, which goes by the abbreviation ISDS, is a mechanism written into many trade and investment agreements that allows individual corporations to challenge laws, regulations, permitting decisions, and even court decisions that they view as a violation of their trade agreement rights. These ISDS challenges aren't heard in the US court system or in any other country's domestic judicial system, but instead in front of an extrajudicial tribunal, often of 3 corporate trade attorneys. These tribunals can't literally overturn a country's laws and other decisions, but the tribunals can award companies millions and sometimes even billions of dollars in taxpayer compensation, such that if a country doesn't want to face additional lawsuits, it changes its policies and it gets in line. Today, we're going to hear more about the details of the ISDS system from Stephanie Camarillo, the research director for Public Citizens Global Trade Watch Division. Before joining Public Citizen, Stephanie worked as an international arbitration and trade attorney representing Latin American governments on ISDS cases, so she's got a lot of firsthand experience with all of this. Then we're going to hear from our friend Stuart True, a senior researcher with the Canadian Centre for Policy Alternatives. Stuart is going to outline an egregious ISDS case filed by the U.S. company Ruby River Capital last year, which is seeking $20 billion after Quebec's decision to reject permits for the firm's proposed LNG plant and terminal near the mouth of the St. Lawrence River. Like the Canadian firm TC Energy's $15 billion ISDS lawsuit against the United States over rejected permits for the Keystone XL pipeline, this Ruby River case is a prime example of how corporations use ISDS in an attempt to pull the rug out from underneath environmental movement victories, and how they pose a real threat to climate solutions worldwide. For those who attended our briefings last year, you'll remember that the Trade Justice Education Fund has been doing a lot of advocacy for a climate peace clause that will put a moratorium on state-to-state trade attacks on climate policies. We likewise advocate for an end to the entire ISDS system altogether, and I think Stephanie and Stuart's presentations will help us all understand why. After they've both spoken, I'm going to come back. I'll be joined by Ryan Harvey from Global Trade Watch, and we're going to talk about the most important part of today's conversation, the global movement against ISDS and how you can make a difference in that movement. As always, we expect to have some time for questions at the end, so please go ahead and put those in the Q&A as we go along, and after we talk through the action steps, we'll get to as many of those as we can. So with that, by way of introduction, let's jump right in on ISDS basics with Stephanie Camarillo. Stephanie, thank you so much for being here. Please take it away.
Hi, everyone. Thank you so much for joining us today. My name is Stephanie, and I am the research director at Public Citizens Global Trade Watch. As Hillary already mentioned, before joining the advocacy world, I was a litigator for many years representing governments in ISDS disputes. So I will be discussing the basics of the system with you and sharing what I've learned firsthand. So let's dive in. I can't quite see if my presentation is up. Can someone just confirm?
It's up, Stephanie. Perfect. Thank you, Ryan.
Thank you. So let's dive into the next slide. Thank you. So what is ISDS? The investor-state dispute settlement system, sometimes erroneously called investment state, is a set of rules and procedures that started showing up in bilateral investment treaties in the 60s. Later on in the 1990s, ISDS cropped up in investment chapters of free trade agreements, the first one being NAFTA. Next slide. So it is no coincidence that ISDS was introduced in the 1960s following the last major wave of European colonies gaining their independence. The system was sold to former colonies by Western nations as a beneficial tool for attracting foreign investment that was much needed for their economic growth and development following centuries of exploitation by colonial powers. But in reality, ISDS was conceived as a way to protect European companies that continued to operate in former colonies that were concerned the new governments would nationalize the industries they were profiting from. So the former colonies, faced with economic vulnerability, inexperience in negotiating these complex agreements, and internal political pressure to stabilize and grow their economies, agreed to adopt ISDS. Next slide. Now, proponents of ISDS claim it is a fair and impartial mechanism to resolve disputes peacefully between corporations and host states because instead of using one party's legal system, the dispute is decided by neutral arbitrators. They also claim things like stability and legal certainty. However, after years of being in the trenches, I can unequivocally say that none of that is true. So, next slide, please. And I apologize in advance for my millennial humor with the memes, but the truth is, the only ones claiming ISDS is a good thing are those profiting from it, either through legal representation, tribunal appointments, the arbitration centers themselves, and of course, corporations love ISDS. So the reality for governments is actually quite bleak because treaties with ISDS provisions grant overly broad rights to corporations. These go beyond protecting the expropriation of their investments and the rights of corporations in domestic legal systems. Even if a law has not been passed, corporations can launch ISDS disputes against governments at the mere hint of a regulatory change that may impact their future profits. And well, who decides these cases? Corporations only have to convince a secret panel of arbitrators, typically three corporate lawyers. And I say secret because the details of the cases are typically withheld from the public, even the communities harmed by the investment themselves. And the award amounts are often undisclosed. So the taxpayers, who are the ones who end up bearing the cost of these cases, don't even know which corporation took their money. So, for some added context, the average ISDS case seeks $1.6 billion in damages. And this lack of transparency is detrimental because it undermines the so called fairness and impartiality of the arbitration process. And it limits the participation and influence of affected communities and advocacy groups. Another key issue with ISDS is the clear imbalance of power. Only investors can sue governments in ISDS, which means corporations are typically not held accountable for any harm that they cause to host states. And they certainly cause harm, as we'll get into in a bit. And also in ISDS, states don't really win. So even when tribunals side with governments, they are often still required to pay their own legal fees and arbitration costs. For context, the average cost of legal representation is nearly $5 million, which can be devastating, particularly for small and developing countries. Not to mention, the countless time that is spent by public officials preparing a good legal defense is time that could have been better spent benefiting their citizens. So, with that in mind, the mere threat of launching an ISDS case can have severe consequences for governments. There are cases where governments become reluctant to enact essential measures for public health, safety, environmental conservation, etc., because they are scared of the costly ramifications of an ISDS dispute. This is what's known as regulatory chill. And as a result, governments are not free to exercise their sovereignty without facing serious repercussions, which pushes them to, at times, prioritize corporate interest over people and the environment. I saw this firsthand when a flood of cases came in following the emergency measures adopted during the pandemic, as governments were just trying to protect their citizens. Next slide, please. So ISDS harms all communities, But Indigenous people are particularly vulnerable to the effects of ISDS and experience what is known as a triple losing scenario. Indigenous people typically live on land that is highly sought after by foreign investors. And so they come in, set up shop with very little regard for the communities, and many times destroy their environment, their ways of life, and livelihoods. In these cases, governments are often caught between a rock and a hard place because they have to choose between protecting the indigenous communities or appeasing foreign investors to avoid ISDS disputes. But even when governments side with the corporation, it is not a guarantee that they won't launch an ISDS case against them anyway. So, next slide, please. This brings us to the Bear Creek v. Peru case, which is near and dear to my heart. Lake Titicaca was once considered sacred by the Inca, and as you can see, it was home to a thriving indigenous community that relied on the lake for fishing and farming. So, when a Canadian company decided to exploit the area's silver, the community protested, saying it would ruin them because mining is known to be a very dirty industry. As you may know, Peru is a target for precious metal mining, so the indigenous community had already seen what happened to nearby communities and did not want the same thing to happen to them. So the Peruvian government even deployed armed forces against the protesters, but the corporation launched the case anyway, suing them for $522 million. And even though the tribunal admitted the corporation had an obligation to consult the local community and obtain their permission to set up the mining project and failed to do so, they still sided with the corporation. Next slide, please. So this is the aftermath. And as you can see today, Lake Titicaca is covered in trash and toxic cyanide runoff from the mines, since that's the cheapest way to separate silver from the rocks. Next slide. Another example is the Chevron v. Ecuador case. So in this case, between the 70s and 90s, US oil giant Chevron dumped toxic waste and crude oil directly into the Amazon rainforest, which led to the countless harms, it decimated an entire Amazonian tribe and killed countless wildlife species. And a domestic court found the corporation liable and ordered them to pay for the harms to the communities. But instead of paying, Chevron sued Ecuador through ISDS, and the tribunal sided with Chevron. The indigenous communities and neighboring people whose livelihoods have been destroyed have yet to obtain justice and likely never will. They were not even allowed to submit an amicus brief for the tribunal's consideration before their ruling, which adds insult to injury, to say the least. Next slide. So after all of that, I think it's fair to say that it's apparent that the system only works for corporations. And I'm very glad that in recent years, governments have begun taking steps away from ISDS, which my colleagues will discuss. And so I want to thank you all for your time. I look forward to answering your questions at the end. And if you ever want to chat about ISDS, feel free to shoot me an email. Thank you.
Thank you so much, Stephanie, for that helpful background. I know that folks are going to have questions for you, and we are going to save that for the end, but I want to remind folks that you can type your questions into the Q&A function at the bottom of your screen. We're going to get to as many of those as we can at the end today. Next, though, I want to turn things over to Stuart True of the Canadian Centre for Policy Alternatives to give us some background on the ongoing Ruby River ISDS case. Stuart.
Yeah, thanks very much, Hillary. And thank you, Stephanie, for that excellent rundown of the ISDS regime. I'm going to share my screen. Hope it works. Okay, can everyone see that? Okay, I'm just going to keep talking and assume that it's all good. Yeah, so thanks again. I'm going to hone in on this Ruby River case, which I think exemplifies the troubling excesses of investor-state dispute settlement, particularly in an era of needed climate action. And it also exposes the challenge that ISDS creates for democratic decision-making and meaningful public participation in things like environmental impact assessments of major fossil fuel projects. But But also, having listened to Stephanie's presentation, I mean, it really does exemplify a lot of those other aspects that she mentioned, especially with respect to, the lack of consideration for Indigenous people's rights in Canada. So anyway, let's get going. This is just a summary of what I hope we can cover in the next 10 minutes or so. I'm lucky to be able to draw very heavily from a report that we put out in December from Scott Sinclair. He's the former director of the project that I currently direct, the Trade and Investment Research Project. And as I said, I'm going to draw from his report on some of the facts around the case. What is the project? What does it look like? How would the project have negated climate action? What was the result of the environmental impact assessment, and how does the case undermine democratic decision-making? So first off, the project itself. Ruby River is a Delaware-based corporation that owns Quebec-based Symbio Infrastructure Partnerships, which between 2014 and 2022, Symbio, formerly known as GNL Quebec, had proposed to build a liquefied natural gas plant and maritime terminal on the Saguenay Fjord near the mouth of the St. Lawerence River, which you can see in the circled area there in the middle of the screen. On top of that, so along with that was a pipeline needed to tie in Western fracked gas pipeline exports that currently go through to Montreal. You can see on the map in the top left, they were going to build an additional pipeline extension to go straight to the facility in Saguenay. And the whole thing was called Energy Saguenay. And you can see in the bottom right, maybe a little bit zoomed in picture of what it looks like there, the topography. While the company and at first the Quebec government assured everyone that the facility would operate with net zero emissions and help countries transition off even dirtier fuels. We know LNG gas is dirty, but even dirtier fuels like coal. It was clear to many at the time, from the beginning, that the project would in fact significantly increase greenhouse gas emissions for decades to come. So a study commissioned by the industry itself found that it would increase emissions by 7.8 million tons a year. An independent life cycle analysis that was eventually introduced into the environmental impact assessment for this project found that it would probably be double that at least, and as high as 33.6 million tons of greenhouse gas emissions every year when you factor in things like fugitive methane emissions across the pipeline system, which is a natural, regularly occurring thing when it comes to these pipelines. And not only were there climate impacts in terms of emissions, but there were huge impacts on wildlife. As the Quebec NGO Équiterre explained, NGO was one of many groups opposed to the project. Over 160 super tankers, which I think most of us know what they look like, but just in case not, here's one here. 160 per year would have been passing up the Saguenay River and through through two marine parks, a marine park and a Saguenay Fjord National Park, which are important conservation areas, renowned tourism destinations, and areas that protect the belugas, but also other species at risk like blue whale, fin whale, harbor porpoise, and several marine birds. So not surprisingly, the project was opposed from the beginning. It spawned a huge province-wide education campaign and solidarity building exercise between Indigenous peoples, environmental groups, community groups as well, as you can see in the top right here, who don't want to see any more industrial development in an already very industrialized part of the province. The Innu First Nations, on whose unceded ancestral lands the project would have been built, publicly opposed the project based on concerns including the negative effects of increased marine traffic on the beluga, negative environmental and aesthetic impacts across the pipeline route and near the Saguenay Fjord, which would affect recreational tourism, in which they're active, and the environmental harm from increased greenhouse gas emissions. So the input from these First Nations, among 2,000 other public submissions to the environmental impact assessment, resulted in the Quebec government deciding in July 2021 that it would reject the proposal based on recommendations to do exactly that from this independent environmental impact assessment. That report again cited concerns around greenhouse gas emissions, but also the cumulative effect of other projects on the environment, uncertainty about LNG demand. So there was an economic element here. The company's projected economic benefits were not sound, this finding said. And there was the possibility that dumping more LNG on world markets would actually stunt Germany's efforts to phase out fossil fuels, for example. So that all factored in. Now, what was the result? Well, we know the result. We kind of talked about it at the beginning, is that Ruby River has filed an NAFTA case asking for $20 billion from the Canadian government for this what they're calling what do they call, a fundamentally arbitrary, procedurally grossly unjust, expropriatory, and discriminatory treatment. As you can see in this news story, the company's trying to make the case that this was all politics, much like in the TC Energy case, right, in the United States. They claim that similar, although we have to say much smaller industrial projects were being approved in Quebec and elsewhere in Canada at the time. Therefore, the company asserts that Canada acted in a manifestly arbitrary and discriminatory manner, contrary to the legitimate expectations of the claimant and Symbio. Now, this strained argument and its request for arbitration, which was put in February 2023, it equates instances where different projects are treated differently for any reason with situations where an investor faces outright discrimination based on their nationality. The companies claim that the Quebec government abruptly changed its position on the project from support to opposition. Their claim that this was only based on politics is completely false. In fact, the Quebec Premier and the Environment Ministers were supporters of the LNG project until this independent review body encouraged the government to reject the project for a number of enormously important and very sound reasons. This is exactly how things should work in a democracy. And yet Ruby River claims that the measures individually and collectively violated 4 different clauses of the NAFTA, including minimum standard treatment, national treatment, as we talked about, and that this expropriated their future profits to the tune of $20 billion, which is absolutely outrageous. Put it here in terms of where this lands in terms of global projects, it's among the most expensive. But here, this is from the UN Special Rapporteur report last July on the negative impact of ISDS on climate measures. Just to say, these are enormous penalties that really do put a chill on environmental measures. So does Ruby River have a good case? I'm getting close to the end here. You would think not on the surface, but here we have, not too long ago, another case against Canada involving a project on the St. Lawrence or close to the St. Lawrence. It was a quarry. And in that case, the panel, from a 2-to-1 decision, the panel did decide that in fact Canada had violated the company's national treatment and its minimum standard of treatment by denying it a permit to build this quarry based on a provincial and federal environmental assessment process. So clearly there is a precedent here. It's a worrying precedent, and it's surely one that the company Ruby River is going to rely on in their cases as they move forward, if it does move forward, which we can talk about later. So finally, where are we at? Well, the tribunal was established in June 2023. It's made up of 3 trade lawyers, as Stephanie was saying. One's from Switzerland, one's from the United States, one's from France. And they're going to make a decision. They're going to be able to second guess Canada's decision or Quebec's decision through this environmental impact assessment. They're going to be able to second guess it. And it's totally inappropriate. This is not the appropriate venue to assess the validity of a company's contentious claims about the project's carbon neutrality. The relevant arguments and scientific evidence have already been examined exhaustively and in an inclusive public forum during the federal and provincial reviews. Both independent reviews came to the same conclusion that the project would significantly increase emissions. And for this and other compelling reasons, as I said, they ultimately denied approval. Unfortunately, it's going to move forward now. It's up to the tribunal. But, if we do have a chance to talk about whether or not that happens, there are questions as to whether the company has standing, just as there are questions to whether TC Energy has standing in the United States based on the Biden administration's oppositions. But I'll leave it there and look forward to questions if there are any. Thanks very much.
Thank you so much, Stuart. Super helpful presentation. I can see that there's a lot of folks putting questions, which we will get to in just a second. So in a minute, I'm going to turn things over to my colleague Ryan to talk about some important action steps that we can each take to dismantle the ISDS system. But before that, I want to set a little bit of context as to where the global movement against ISDS stands. There's a lot of questions coming in about ISDS and the new NAFTA and all of that, so I'm going to address some of those things right now. The good news on ISDS is that over the decades, trade justice activists have done so much advocacy and public education work against ISDS that both President Biden and former President Trump are officially against it. An expansion of ISDS is not a feature in any pending U.S. trade proposals, and it hasn't been for a long time. The work that remains, at least for those of us in the United States, is now disentangling ourselves from existing trade and investment pacts that contain ISDS, while also bringing an end to what are called state-to-state trade attacks on climate through a climate peace clause. So, like many folks are noting in the Q&A box, the work of getting rid of ISDS started during the NAFTA renegotiation. TC Energy's Keystone XL Pipeline ISDS case and this Ruby River LNG ISDS case are both cases that were brought under old grandfathered in ISDS rules that expired last summer. So those two cases are moving forward under the old rules, but fortunately new cases like those against the United States would not be possible under the revised NAFTA, which is I guess goes by the acronym, the US-Mexico-Canada Agreement. I remember at the time, for example, hearing that eliminating ISDS between the US and Canada would eliminate something like 93% of the US ISDS liability. So that said, ISDS wasn't eliminated completely within this pact. Within the US-Mexico-Canada Agreement, ISDS still remains in place exactly as it was before for oil and gas firms with fossil fuel contracts in Mexico. So Mexican environmental action remains in jeopardy here. And beyond that, just in the Americas alone, there's a spaghetti bowl of something like 43 trade and investment agreements from which ISDS needs to be eliminated. So like I said earlier, since the main ISDS threat to the US was eliminated via the NAFTA renegotiation, we believe right now that one of the biggest threats to climate action in our country is currently some of the state-to-state trade challenges, like the threatened challenges against climate measures within the Inflation Reduction Act. But now is the time to completely eliminate the ISDS threat to the US altogether, and to eliminate the very serious and ongoing threat that ISDS poses to other countries, particularly those in the global south. In fact, the movement in the global south against ISDS is quite large and growing. Ecuador, India, Indonesia, and South Africa are among countries that have begun to review, restrict, and extricate themselves from deals that include ISDS. We're seeing similar efforts from European campaigners and folks in Canada and New Zealand and in the UK and elsewhere. As a result of all this work, the ISDS system is really vulnerable right now. And here in the US, at a moment when the leadership of both major political parties agree that ISDS is an affront to democracy, we need to take advantage of this opportunity to kill it off once and for all. So the Biden administration's ongoing America's Partnership for Economic Prosperity dialogues, which are talks with Latin American countries focused on creating sustainable investment relationships in the Americas, is one particularly great opportunity to advance ISDS elimination. In a minute, we're going to turn to some of your questions, but right now, I want to turn to Ryan to talk about some action items on how you can amplify calls for eliminating ISDS in the Americas. Ryan, go ahead.
Cool. Thanks, Hillary. And thanks to Stephanie for your presentation. Hey, everybody. I'm Ryan Harvey. I'm the National Field Director at Public Citizens Global Trade Watch. So there's two actions right now that we're really pushing and that we need help with. When I say we, I mean Public Citizen, the Trade Justice Education Fund, a bunch of other organizations, some of whom are represented here on the call. We're part of a large network of groups who are fighting for better trade policies and against things like ISDS. So the first one I want to mention, because we've been talking about Latin America, is an initiative around removing ISDS from the Central America Free Trade Agreement, which involves all of Central America as well as the Dominican Republic. This is, right now there's a letter being signed by members of Congress, and we're really trying to get as many members of Congress signed on to this letter as possible, calling on the Biden administration to take steps to engage with member countries of the Central America Free Trade Agreement and try to get ISDS removed from it. So this isn't going to be applicable to everybody, because if you're not in the district of one of the members who are on the target list, it might not be a super worthwhile thing to engage on. But if you have contacts in other places, or you just want to help try to get members of Congress signed on, it would be really helpful. But the list does have over 100 people on it, so it's possible that you're in one of those districts. So you can, there's an action that was just shared in the chat, which is just you can sign up real quick and send a letter to your member of Congress about it. And then you can also, I'll throw my email in the chat. You can contact me or Hillary if you want to engage further and see what else you can do to help get members of Congress signed on. These letters are really important, right? Like, this is a way to build consensus. It's a way to build political pressure. And it's also a way to have this conversation with congressional staffers, with members of Congress, and with the general public when we do publicity, when we put these letters out. So step one is getting the letter together. Step two is getting members of Congress signed onto it, engaging folks like you all to help with that. And the third one is to make it public and to make sure it has an impact. And this is the way that we've done, this has always been a tool we've used throughout our campaigning when we were trying to get ISDS removed from the NAFTA, and when we've been fighting around various trade agreements in the past. So it may feel like kind of a boring task, but it's a very impactful task. So that's the CAFTA campaign action that we have right now. And again, that link is in the chat right now. The second one applies to everyone here if you're in the United States, which is we have another letter being led by a few state legislators from around the US. And we're trying to get 200 or more state legislators to sign a letter to the White House as well, calling for the removal of ISDS from all existing trade agreements to which the US is party. And like Hillary said, there's the big ones like CAFTA, but then there's a bunch of small side, especially with investment treaties that I don't even know the names of all of them that contain ISDS. So in the past, we've mobilized state legislators a number of times around ISDS. And so we're doing that again. And this is very important for state legislators because ISDS cases get launched by foreign companies against a domestic government. But they don't have to target a federal law. They can target a local law. They can target a state law. They can target a Supreme Court ruling. There was a case where a foreign company launched an ISDS case to challenge a Supreme Court ruling in Massachusetts. There was a company who launched a case charging a local court ruling in Louisiana, or in Mississippi, sorry. So this isn't just about the federal policy. So that's the story that we're telling when we engage with local legislators. The chill effect, doesn't just impact, your senators and your members of Congress. It impacts state legislators, and in some cases, with some of the cases in Latin America, even very localized decisions, very local forms of government decisions have been challenged. So both of those links are in the chat. If everyone here has probably got a state legislator, so definitely take that action. But also, if you want to try to get other state legislators in your state on board, even if they're outside of your district, we would love the help. We can help you put together a target list. We have template outreach emails you can use. We can help set up meetings with these folks. But a team effort to try to get as many legislators from your state on board will go a really long way. So yeah, those are the two actions. Again, I'm going to put my email in the chat so you have it, and you can contact me or Hillary to follow up on any of those things.
Awesome. Thank you so much, Ryan. I really want to encourage folks to please take those actions. Links are in the chat, and I'm going to be sending you a follow-up email, I think within the next 24 hours with more information. So knowing about the threat of ISDS to climate action only matters if all of us are taking action to eliminate that threat. One other thing I really want to mention, quickly related to the Ruby River case, is that Ruby River and its major investors have offices in California, in Texas, in Delaware, and in Quebec. We're planning some in-person actions calling out the firm's ISDS suit. If you're in California, Texas, Delaware, or Quebec, and want to learn about how you can get involved in those actions, please shoot me an email, and I'll put my email in the chat in just a second as well. But it's Hillary, Hillary, at tradejusticeedfund.org, and I'll be sure to connect you with the appropriate local organizers for each of those actions. So now I think we're going to take some questions. I want to remind folks to please put those questions in the Q&A. The first one that I want to address is actually for you, Stephanie. Susan says, Stephanie, great talk and historical analysis. Please talk about how damages are determined in ISDS proceedings. I wonder if there's anything that you could share with us on that.
Sure. So as I mentioned, the damages sought for the average case are over $1 billion. And in many cases, like one that Susan and I are working on, they're 11 billion. And that amount is honestly pulled out of a hat. The investors just come up with a number because, as I mentioned, they can sue not just for damages of like their lost profits that already happened, but expected future profits. And so they can just make up just about any number and they don't really have to justify it. It's up to the government to hire damage experts to bring those costs down to earth. But even then, every tribunal is different, and every tribunal can award whatever damages they feel are fair in compensation for whatever government action brought the case in the first place. And so there's no real consistency, there's no real formula. And that's part of the frustration with ISDS, I would say.
Yeah, just to give more legs to what Stephanie's saying. I remember when the Keystone XL pipeline permits were getting like pushed back and forth, right? Obama pulled them and then Trump put them back into place, and then I think Biden withdrew them again. Like as that case has been pushed back and forth, it became clear, right, that the amount of TC Energy's like initial investment was like $3 billion, and they were trying to get 15 billion out of that ISDS case. It's insane the amount of money that they can pull from taxpayers just to have permits revoked, that kind of thing. One question, and Stephanie, you might be able to address this. Stuart, you might be able to address this. So I'll kick it to you guys first, and I'm happy to chime in too. Is there any way that the public can influence ISDS cases?
So the one avenue that is honestly left is the submission of the amicus brief. I talk about it briefly in Indigenous participation as it pertains to the triple losing scenario in one of those slides. And essentially, it's a third interested party brief that the communities impacted can submit directly to the tribunal. However, there is a huge downside, and that is that they're not automatically approved by the tribunal, even for submission. So it's entirely possible and likely that a community could draft a report, even citing like expert sources, explaining the damages that the investor caused, or presenting a timeline on how things really happened. And the tribunal could just dismiss it entirely, and therefore it would have no influence on the case at all. So that's the amicus brief. Another way I would say is a bit more indirect, and that is through like the pressure of advocacy. But I'll let Stu see if he wants to add anything.
No, I don't think I could add anything to that, Stephanie. I mean, it's very hard, right, once the cases start to kind of have some official role, right, for citizens groups in that proceeding other than an amici submission. But, there's occasions to do things like what you were just mentioning, Hillary, putting pressure on companies, right, to back down. That is something else we can try to do, and get some action that way. And of course, also pressuring our governments to just get out of these investment treaties, right, so that we don't see these kinds of cases down the road.
I'll share just quickly that in my former role, I was the executive director of the Washington Fair Trade Coalition in Washington State, where I live. And we had a situation where a bunch of non-native fish that were being farmed in the Puget Sound got out, essentially, of the containers that they were being farmed in, got, all over the Puget Sound. And the state was really upset about it. And there was some effort in the state legislature to pass a bill to limit the kind of fish farming that would happen in the Puget Sound, basically. The company that was doing that farming was Cook Aquaculture from Canada as well. And they showed up in our state legislature and threatened a $76 million ISDS lawsuit through NAFTA to the state over that legislation. Now, there was a lot of like public outcry about it, right? And there were articles in the news and activist groups that were kind of making a big deal about the situation as it unfolded. And in the end, that bill did pass on the very last day of the legislative session because the state took a really long time to consider whether or not they wanted to pass that law that would tick off this Canadian company and potentially bring this ISDS case. They did end up passing it because of all the public attention on the process. Cook Aquaculture did not ever actually file that case. But that's, you know, an example for me, both of the chilling effect on different regulatory processes and that kind of thing that can come from these situations, and also an example of a moment when public pressure worked, right? We still got the law that we wanted in place, and that suit was never filed. So yeah, wanted to share that example here. One other question that I had, someone message me, this is the question. I'm confused about the difference between the work against ISDS and the work for a climate peace clause. Can you explain that a little bit more? And I'm going to take a stab at explaining that. So there are two major ways that trade agreements can be used to attack climate policies. One is by individual corporations through ISDS. The other is by foreign governments through what are called state-to-state trade challenges. So you have investor state challenges, corporations challenging governments, and you have state-to-state where governments challenge governments. So both of these kinds of challenges, countries can face billions of dollars worth of penalties if their climate policies are found in violation of outdated corporate trade rules. Taking advantage of the opportunity that we have right now to eliminate ISDS is really, really important. And in particular, you know, it's particularly important for eliminating ISDS attacks on smaller countries in the global south that cannot afford the liability of these expensive ISDS cases brought against them, and often feel pressure to change policy simply because an ISDS case is being threatened. For the United States, especially now that we've eliminated a large part of our ISDS vulnerability through the NAFTA renegotiation, the bigger threat to our climate actions remains the state-to-state cases. Over the years, the U.S. has lost state-to-state cases related to parts of the Clean Air Act, the Endangered Species Act, the Marine Mammal Protection Act. Many of our classic environmental policies have been impacted by state-to-state. In terms of climate policies, a recent example of this is the EU, South Korea, Japan, and other governments threatening trade suits against the electric vehicle and wind power elements of the Inflation Reduction Act, saying that they're trade pact violations. Biden administration has spent a ton of time and political capital trying to appease those governments, time and resources that honestly would have been better spent addressing the climate crisis itself. Perhaps even more importantly, the threat of state-to-state trade attacks is also slowing progress on a bunch of other large-scale climate actions, which again is time that the world does not have to waste. So because of all of that, the Trade Justice Ed Fund, Public Citizen, Sierra Club, and tons of other environmental-minded organizations across the U.S. have called for what's called a climate peace clause, which is a moratorium on the use of these state-to-state trade attacks against countries' green energy and climate policies. Bottom line is basically that people need to be able to enact these policies that are designed to rapidly reduce climate pollution and to rapidly expand green energy alternatives. They need to be able to enact those policies free from restraints from outdated trade rules that put corporate profits ahead of a livable planet. Ultimately, we need to rewrite and fundamentally transform our trade agenda and our trade agreements so that they're actually good for the planet. But that's a process that many of us know is going to take a long time to get global consensus to get those policies in place. So in the meantime, we need to stop all these investor state attacks on climate by getting rid of ISDS and stop the state-to-state attacks via a climate peace clause. So I hope that that helps answer that question. I'm going to drop a couple links in the chat right now that have explainers on the climate peace clause. Make sure. There we go. There we go. Let me see if we have any other questions. All right. So I think before we close out, I want to thank Stephanie and Ryan and Stuart. Stephanie and Stuart, any final words for our audience before we close out for the day?
Well, I just, again, thank you, Hillary, for the chance to be here. And it's just knowing, like, the work that you do and Public Citizen does around ISDS, I just want to say how how much we appreciate it in Canada and how inspiring it is. And so just to say doubly thankful to be here and to be part of that. And I do hope to stay in touch with everyone here, and anyone can get in touch with me to talk about how we can cooperate on these things in the future, stop ISDS in both countries.
Yeah, I'll just add that I think ISDS thrives in obscurity. And so all the work that everyone is doing, bringing this to light, is super important. Anyone that you can talk to like, when you tell them what ISDS is, they can't believe it because why isn't it on the news? This is insane. So I would say that talking about this, putting presentations together like these that I'm super happy to be a participant in, any kind of questions that I could answer for anybody at any point, I'm more than happy to talk about this because I am convinced that talking about this, exposing this, is what's ultimately going to eradicate this. So, yeah, thank you.
Really appreciate those comments, Stephanie. I remember the first time I presented about this to master students, and one of the students raised their hand and said, "Why would we ever do this? Why would we ever do this in the first place?" Just echoing that sentiment. Ryan, any last words before we close out?
No, just get in touch with us. Let's drag this thing out of the shadows, and let's put political pressure on the folks who have the power to stop it. And just based on what Ken said, yeah, if you have like a radio show or anything like that, or you want one of us to speak to your organization, get in touch with us. We'll do it. It's what we're doing.
Amazing. I want to thank our speakers one more time. I'm seeing a lot of love for you all in the chat. You've done a great job, and thank you for bringing your expertise. I want to thank everyone for attending, and I am going to be sharing a recording of this and links to all the action steps in a follow-up email probably tomorrow. So just want to thank everyone so much, and have a great afternoon. Bye, everyone.